Hello, everyone. Sufit here. I am here today with Charles B. Ticker, estate mediator and litigator, in another episode of Mediation Minefield. What can make your mediation blow up or fizzle out without settlement? So, Charles, today what I'd like to have you address is how lawyers might get in the way of a good result in mediation, how a lawyer might actually by his or her conduct make the mediation blow up or fizzle out. What do you have to say about that?
Well, I think what lawyers have to realize is that when they're at a mediation, it's a totally different form of advocacy. You're not in court, you're not arguing a case before a judge trying to get the judge to go along with your line of reasoning so the judge will find for your client. That's not my role as a mediator. And I say that in my open remarks. I'm not here to make any decisions or to give uh, legal opinions. Having said that, mediators such as even myself will, if the parties are getting close to settlement, and I feel there's a little resistance there, I might put a little pressure on and lean on them a little bit with my views. But typically, it's trying to get them to focus on what could happen if they're wrong at court and what it's going to cost them and what it's going to look like. But sometimes we have counsel mediations who have not prepared their clients properly for the mediation. They have not managed the client's expectations. They've told the client that they got a sure winner and the other side's got a sure loser. So that poses a problem. And I always explain in my open remarks that as lawyers, we've all had cases that we thought were sure winners and we've lost, and we've had cases that we thought were sure losers and we've won. And I talk about, cases settled because nobody knows what a judge is going to do. You just can't predict. So it's so important for the lawyers to prepare their clients properly and manage expectations. I also always tell the parties that today's your day. I want to hear from the parties. So when I have a situation where I feel when I'm meeting with the clients privately with their counsel, that the lawyer's doing all the talking and the client's just sitting back there and letting the lawyer do all the talking, I very politely try to engage the client and push the lawyer more to the background because I want to hear what you have to say. Uh, and, regardless of what the legal arguments may or may not be, what's today about? Today is about trying to resolve this dispute and getting on with your life. And what does that look like? And what's it going to take to get you to move on with your life? So it can be challenging if you have a lawyer who thinks they're arguing at the Court of Appeal and looks at settlement or mediation as sort of giving in to the other side, because we talk about compromise. But what lawyers have to appreciate, and it's in our professional rules of professional conduct here in Ontario, is that we have a positive duty to encourage settlement, not to encourage, protracted and expensive litigation. Um, and settling is not losing. Settling is a big win for everybody, even though both sides might feel like they've lost. Well, maybe that's a fair settlement. But the lawyers really have to do a really good job of preparing the client for the mediation, or you could have a real problem.
So, Charles, as a mediator, do you sometimes notice lawyers maybe showing off a little bit for their clients? I mean, is there a fear amongst lawyers that if the lawyer doesn't advocate fiercely or like a shark um, for their position, uh, even in a mediation, that later when they leave, the client is going to say to the lawyer, "Why didn't you fight for me? You just rolled over and played dead. You gave in." I mean, is it? Do you ever see that kind of dynamic?
Well, I've definitely seen that dynamic both as a mediator and as a litigator. Uh, Clients get very enthralled with their case, and obviously, when the lawyer takes it on, the lawyer's going to say, yeah, we got a great case here. I think we can score on these points. But cases change as more information comes out, as there's more evidence or more documents. And as also there's litigation fatigue and litigation costs. Client maybe starting to get a little stressed out, a little tired with the litigation. It's getting very expensive. And then, there's the uncertainty what's going to happen at trial. So, yes, parties sometimes don't understand, well, why you telling me to settle? You told me I had a great case. And so that is a challenge. But as counsel, I think the client has to be told that there's litigation risk. And if a lawyer says it's 50-50, 60-40, nobody can give you those odds. You might as well just go to Vegas and roll the dice. So clients just don't appreciate the risk involved in litigation, and they really have to understand like what their worst case scenario is. So, your best case scenario, you win your case, but what does that mean in real dollars? Because if you've spent tens of thousands of dollars to get there, you may not get all your costs back. And what's your worst case scenario? You could be out, hundreds of thousands of dollars in legal costs. And I think if clients have a better sense of where what's involved, hopefully they'll sit down and try to make a better assessment of whether or not they should settle. But I find the most difficult cases are not the ones where there's the big money. It's the smaller cases where they're chasing this relatively small pot of gold at the end of the rainbow and spending money totally out of proportion to the amount of the prize. So once again, this is where it's being driven by emotion and lack of trust, and we got to work really hard on working on those aspects if we're going to settle the case.
So in terms of the possibility of blowing up the mediation and the chances of settlement, the lawyer can definitely play a part from everything you're saying. And Charles, are lawyers trained specifically for mediation, for their role in mediation, the way that they might have had training to appear in court? Or is this something they're just sort of, they appear trying to win the same as they would try to win in front of a judge?
Well, I would hope that lawyers are being trained now in law school, that courses are being offered on alternate dispute resolution methods. I would think they are, but certainly when I went to law school, we weren't taught much about anything practical lawyering, but certainly mediation wasn't even really in vogue then. So no, and one just has to realize like 95% of these cases settle without going to a full hearing. Why is that? Because people run out of steam, they run out of money, or they settle, or because there's this uncertainty what a judge is going to do. So I think if people understand that the odds are you're going to settle at some point down the road, why not do it today before you spend tens of thousands of dollars? And that's what I hope the lawyers are telling their clients. But sometimes maybe the lawyers just see this as an opportunity to continue charging. But I always make a point in my opening remarks. I said, today's the day you can stop those legal fees and stop the lawyer's clock. And I sort of like apologize to lawyers for saying that in a joking fashion, but just say, look, this is your chance to put this behind you. So hopefully, parties get the message.
That's a good point. And I imagine also, another reason for lawyers not deliberately trying to quote unquote win in a mediation is, what if they do end up convincing the mediator? Then the other side is just going to think that mediator is not impartial, and the whole role of a mediator is to impartially be a facilitator. No.
Well, there's no question that could happen, and that could happen sometimes without the lawyers really saying too much. I mean, you can sometimes just by reading the briefs, and this is a challenge. As a mediator, you get a sense like someone's case is kind of weak here. If I was the betting man, I would bet on the other side. But if you're going to have any chance of settling that case, you can't go into that room and say, your opponent's got the stronger case. I think you should
Yeah.
settle, because they just won't talk to you.
Right.
So when lawyers will say, Charles, don't you agree that they're totally out to lunch here? I got to be very careful how I answer that question, particularly with their client in the room, because if you give the wrong answer, they're just going to dig their heels in and you're not going to settle the case.
All very good points. Thank you very much. Our guest today has been Charles B. Ticker, estate mediator and litigator, in another episode of Mediation Minefield: What can make your mediation blow up or fizzle out without settlement? Charles, thank you very much.
My pleasure.